Any other questions?
I would just comment that I would agree that it wouldn't be dependent on what the outcome of the vote would be, whether or not there was a right to vote or not. So I think that's irrelevant whether the numbers would have changed.
Okay. Any other questions of either the parties, or else I think we should begin our deliberations? Discussions? Okay, this is a new one for me, so...
I'll be happy to frame the discussion, at least from my way of thinking about it, and put it out on the table for consideration. We really have two provisions of the Code of Ethics that are in play that have been cited by Mr. Roth. And I'd like to address them separately. Section 2-104-020 says a public official who has a private interest in any law or policy proposed or pending shall not vote thereon. I disagree with Mr. Roth's interpretation of the law. I do not believe that appointment of someone to fill a vacancy is either a law or a policy. The process by which the council appoints someone may be a policy. This is our policy for appointments. But the actual vote to appoint is neither a law nor a policy. Now, the county council could revise this provision, and it could say any action in which he has an interest. But that's not what it says. So this is neither a law nor a policy, so I don't see a violation of 2-104-020. That then takes me to 2-104-034A, prohibited acts. It says that no county official may use his or her position to secure a special privilege or exemption for himself. I interpret that as saying that the position that a council member occupies cannot be used to gain something else that he or she doesn't already have. Mr. Nelson, as an elected councilman, had the right to vote. I mean, he had a vote. That's part of the position that he occupies from the time he was elected and sworn into office. He has a vote. So I don't see how it can be said that he used his position to secure a special privilege. I mean, you'd have to say he used his position to secure a vote. He didn't use his position to secure a vote. He had a vote by virtue of the fact that he held the position. So I can't see how that provision was violated. And it came home to me when I read Mr. Roth's submission on appeal.
I object.
He says that this was a special privilege that Mr. Nelson not only obtained by virtue of his office, but one that he fully exercised voting for, against, or abstaining from voting on his opponents. It says Mr. Nelson had the ability to throw his votes in a way that could weaken the potential success of his strongest opponents or result in a tie vote. Moreover, his failure to vote for several candidates deprived him of a majority. So, in reality, if he voted under Mr. Roth's interpretation, he violated. If he abstained it, he violated it. And that kind of leads me back to this whole issue. You can't use your position to secure something that you're not entitled to. But he has the vote. So he didn't use his position to secure anything he didn't already have. So I don't see any violation of the code as I read it.
It seems clear to me that recusing himself from voting on his own position was necessary and was done. There was clearly a private interest there. It's my belief that there was no private interest, as I understand it from the code, in voting on those other members that were nominated. It may not be the best procedure. I might suggest to the county council that they want to change that, but I think under current rules that I would not find that a violation.
I side with Mr. Roth on the perspective that I think this is a difficult environment. This is a difficult process that no councilman, I think, should be put into a position of because of just the perception it creates. I agree with you on the first point. I don't see this as a matter of law or policy. I'm giving thought to your second point at this point about the securing of a special privilege. So give me a few minutes.
Okay. Well, we have time. We have time. I agree on the first one. The second one, just I can go both ways at times, and because the special privilege was, I'll look at this again, was none of the other candidates had the ability, but granted that at the same time they had not been given that authority by the public, so of course they would not have it. And I would agree, if the council decided to make the rules more clear, it might be easier, the code more clear.
I mean, it really isn't fair to, in people in public life, at the end of the day, all they have is a reputation. And it seems as though there ought to be clear rules we ought to strive for the greatest clarity possible so that people can navigate correctly, so that they're not hung with an unethical label for certain behavior. So from the county council's perspective, they may want to relook at these rules and use this as a teaching moment to provide the best possible clarity for both elected officials and for the public. So that, because after all, it is the law that sets the public's expectation.
My perception in reading the voting patterns and listening to the video was, and obviously I can't speak to what was in your mind, but the impression I got was the voting patterns on both sides were along fairly partisan lines that didn't seem to be designed. The voting patterns on both sides appear to be on partisan lines and not to derive a particular benefit from Mr. Nelson.
Well, since we seem to be in agreement on the first and hung up on the second, let me go back to the second. I kicked this around a bunch of different ways, and I asked myself, if the special privilege is the vote, then I asked myself, did Mr. Nelson use his position to get a vote? To get the right to vote? And the answer is no. It is part of the position. It comes with the territory. It is something he already has. So he didn't use his position to get anything he didn't already have. He didn't use his position to secure a vote. He had the vote.
And actually, to your point, none of his votes resulted in his appointment.
No, he can blame that on the county executive.
No, but the county executive, the county executive was the one who appointed him. And at the time that this went to the county executive still had the option to choose any one of the candidates.
That's right.
That's why you can't look at the special privilege as the appointment.
Right.
You have to look at the special privilege as the vote. And he already had the vote when he walked in.
Right. He did not secure the position as a result of his vote.
Exactly. Well, he did not secure the. He did not use his position to secure a vote. He had the vote. He had that special privilege on all of us, except other council members. He's got a special privilege. He gets to vote on whatever comes before the council, unless he's prevented from doing so.
I think to me, that's the crux. Is, as you say, he had the right to vote by his position, and that the decision to appoint him was made by others. It was not made by him, and it was made by others against a slate of 25 other candidates. Because unless I misread the process here, the fact that no one won did not result in anyone being eliminated for consideration by Executive Crammett. Is that correct?
Yeah. The Mr. Ross' point, of course, is that it's the ability to vote on those nominees that's the special privilege.
So the fact that the council was stalemated forced all 25 or 24 candidates to be submitted to Council Crammett.
Yeah, it doesn't. Yeah, that's what happened. But from Mr. Ross' point, that's immaterial. He's saying it is the vote itself that is the issue. And so then the question is, did Mr. Nelson use his position to secure the vote? And I'm just repeating myself. He already had it.
Or to have the private interest. And we already sort of agreed, I think, that he did not have a private interest because of the law policy definition.
Yeah. I mean, you'd really like to see that. That provision should probably be rewritten to say on any matter that comes before the council, you can't vote if you have a private interest. But
because that's the one that says very clearly that a council person should not vote.
Right. But that's...
But we've just taken it away.
I mean, this is not law policy. So.